Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. We are talking about the various applications and processes at USCIS Manila. In this regard, there's something called the CSPA. Now, there's a particular provision that even though it doesn't have the word Manila or Filipino in it, that's who it specifically applies to. Um, in the entire world, when there is a petition in the U.S., basically a lawful permanent resident petitioning a son or daughter, and then that petitioner becomes a U.S. citizen, the rest of the world, there's years less waiting time to become a lawful permanent resident. But unfortunately, because there's so many people immigrating from the Philippines, when the petitioner in that case becomes a U.S. citizen, it then actually backdates it and takes years longer to become a lawful permanent resident. Well, there is a provision under the CSPA, the Child Citizenship Protection Act, which essentially says that if the beneficiary submits the proper documentation, basically opting out of that automatic preference change, which would be essentially from preference 2B to preference 1, then essentially the petition goes forward as if the petitioner was still a lawful permanent resident, thereby saving years of waiting time. So at the USCIS Manila, it is possible to file the request under the CSPA. Basically, on August 6, 2002 is when this went into effect, and it is now also codified in the Immigration and Nationality Act, referred to as Section 6 of the CSPA. And it basically, what happens is the beneficiary can now file with the appropriate official at the Manila USCIS to opt out of that preference and to follow this provision under the CSPA in order to be able to take advantage of this. So all that can be properly filed at the USCIS Manila, and once it's done and once all the procedures are followed, it then goes under the prior preference petition. Okay, more on the coming video.